On March 1, 2016, then presidential candidate Donald Trump held a campaign rally in Louisville, Kentucky. Several protesters attended the rally, including Kashia Nwanguma, Molly Shaw, and Henry Bourseau. During the rally, Nwanguma held a sign depicting Donald Trump's head on the body of a pig. Though the protesting was allegedly peaceful, during the rally, Trump shouted into the microphone, "Get him out of here!" In response, several members of the crowd began heckling the protesters, and three Trump supporters allegedly assaulted them. Matthew Heimbach shoved Wanguma and Shaw towards the exit. Alvin Bamberger shoved and allegedly struck Nanguma, and an unidentified person punched Bourseau in the stomach. During the interaction between protesters and Trump supporters, Trump continued, "Don't hurt him. If I say go get him, I get in trouble with the press." A portion of the incident was captured on video, and Trump, Heimbach, and Bamberger admitted some of the actions alleged. As a result of the incident, the protesters filed suit against Donald Trump, his campaign, and the three Trump supporters. In the complaint, Nwanguma, Shah, and Bourseau alleged assault and battery against the three Trump supporters, and they claimed that Trump should be vicariously liable for his supporters' actions. Furthermore, protesters alleged that Trump should be liable for inciting a riot and negligence. In response, the defendants filed motions to dismiss. Among other things, President Trump argued that he cannot be held liable for incitement as his statement, "Get him out of here," was constitutionally protected speech. But was it? What speech is protected by the Constitution and what speech is not? What makes certain speech worthy of constitutional protection but not others? The First Amendment states, "Congress shall make no law abridging the freedom of speech." Freedom of speech is considered a fundamental right, recognized as essential to self-fulfillment, happiness, and the development of one's belief, learning, and the democratic process. Political speech is the most valuable form of speech, as it includes matters of public concern and is essential to the exchange of ideas in a democracy. In fact, the court has recognized that political speech is so important that in our public debate, our own citizens must tolerate insulting and even outrageous speech in order to provide adequate breathing space to the freedoms protected by the First Amendment. However, there is no First Amendment protection for political speech that is dangerous or harmful. Therefore, dangerous or harmful speech can be prohibited. Lewd or obscene speech, profanity, speech that is libelous, and speech that incites violence, including fighting words, have all been determined unworthy of constitutional protection. Fighting words are defined as words so inflammatory that by merely speaking them, one inflicts injury or causes a breach of the peace. Fighting words are not essential to the expression of ideas, and one can express ideas without them. They have such slight value in truth-seeking that any benefit they may bring about is outweighed by the detriments they cause. Though fighting words are clearly unprotected, since the mid-20th century, the Supreme Court has whittled away at this category, leaving it as a mere sliver. Specifically, fighting words must have a direct tendency to cause acts of violence by the person to whom individually the remarks are addressed. Insulting, harsh, or abusive words are insufficient. Fighting words must incite immediate violence or panic. Applying these things to President Trump's case, it is imperative to recognize that different legal standards apply to the parties at the hearing when you're talking about a motion to dismiss. First, the court must take all allegations in the complaint as true. Second, for allegations of a complaint to survive a motion to dismiss, the court must find only that the allegations are plausible. As a corollary, to win on a motion to dismiss, a defendant's argument must demonstrate to the court that the allegations of the complaint are not plausible. These lower standards must apply in the preliminary phase of trial to avoid unreasonably limiting plaintiffs' access to the courts at a time when discovery has not yet been completed. In an attempt to demonstrate that the plaintiff's claims were implausible, Trump claimed that his comment, "Get him out of here," was constitutionally protected speech that would shield him from liability. The court, however, disagreed. Judge Hale, the presiding judge, held that the complaint did adequately allege that Trump's statement was unprotected speech because it incited riot or solicited violence, just like fighting words. In making this determination, the court applied the so-called Brandenburg test, which was established in a U.S. Supreme Court case called Brandenburg versus Ohio. According to this test, speech incites violence where 1. The speech explicitly or implicitly encouraged violence or lawless action, 2. The speaker intends that his speech will result in violence or lawless action, and 3. The imminent use of violence or lawless action is the likely result of the speech. Applying the first prong of the test, the court found it at least plausible that Trump's comment at least implicitly advocated violence based on its tense. The phrase, "get him out of here," was imperative, giving instruction, or an order, or a command to the members of the crowd. Second, the court found it plausible that the president intended his statement to cause violence based on the supporting facts that were specified in the complaint. However, Judge Hale did note that under the plausibility standard, it was unnecessary to determine whether Trump actually intended for violence to result. It's enough that he knew that violence may result from his statement. Third, Judge Hale found it plausible that the likely result of Trump's statement was imminent violence. The strongest support for this conclusion was that Trump's statement actually did result in violence. The court dismissed Trump's counterarguments that a riot did not actually result and that the protesters were trespassers. Kentucky law defines incitement as provoking or urging others to commit a crime, though a crime need not actually occur. The court also held that the protesters were not trespassers, as they had purchased tickets to the event. The motions hearing were not a total wash for the president, however, as the vicarious liability claim was in fact dismissed. Since Judge Hale will likely preside at trial, the outcome of Trump's freedom of speech argument at the motions hearing may provide insight as to the likely outcome if Trump were to again offer this argument at trial. At trial, however, the plausibility standard would not apply. At trial, the plaintiffs would have to prove that it is more likely than not that Trump incited a riot. This is the preponderance of the evidence standard that the plaintiff must meet in any civil trial. Trump could argue that his speech was political speech, necessary for the expression of political ideas, though this seems an unlikely argument to work. Alternatively, he could demonstrate the failure of the Brandenburg test by saying either that the speech did not encourage violence, that he did not intend for violence to result, or that the imminent violence was not a likely result. The second prong, his intent or knowledge as to whether violence would result, appears to be his strongest argument. How do we balance the need for freedom of speech with the need for physical safety and social order? If we eliminate and punish all speech that we find disagreeable, then we bind and gag not only our opponents, but also ourselves. Whatever standard is imposed will apply equally to all, president or protester, Republican or Democrat.